Bautista versus Court of Appeals, GR number 143375, July 6, 2001. The elements of BP22 are: number 1, the making, drawing, and issuance of any check to apply for account or for value. Number 2, the knowledge of the maker, drawer, or issuer that at the time of issue he does not have sufficient funds in or credit with the drawing bank for the payment of such check in full upon its presentment. And third, the subsequent dishonor of the check by the drawing bank for insufficiency of funds or credit, or dishonor for the same reason had not the drawer, without any valid cause, ordered the bank to stop payment. The facts of the case. In April 1998, petitioner Ruth D. Bautista issued to private respondent Susan Alonia Metrobank check number 005014037 dated May 8, 1998 for 1.5 million pesos drawn on Metrobank Cavite City branch. According to private respondent, petitioner assured her that the check would be sufficiently funded on the maturity date. So on October 20, 1998, private respondent presented the check for payment. The drawing bank dishonored the check because it was drawn against insufficient funds. On March 16, 1999, private respondent filed a complaint affidavit with the city prosecutor of Cavite City. In addition to the details of the issuance and the dishonor of the check, she also alleged that she made repeated demands on petitioner to make arrangements for the payment of the check within 5 working days after receipt of notice of dishonor from the bank, but that petitioner failed to do so. The issue now is whether or not petitioner can be prosecuted under BP22 even if the check is presented for payment after 90 days from its due date. According to the Supreme Court's ruling, the petitioner is still liable in violation of BP22. The bouncing checks law penalizes 2 distinct acts. First, making or drawing and issuing any check to apply on account or for value, knowing at the time of issue that the drawer does not have sufficient funds in or credit with the drawing bank. And second, having sufficient funds in or credit with the drawing bank shall fail to keep sufficient funds or to maintain a credit to cover the full amount of the check if presented within a period of 90 days from the date appearing thereon, for which reason it is dishonored by the drawing bank. The check involved in the first offense is worthless at the time of issuance, since the drawer had neither sufficient funds in nor credit with the drawing bank at the time, while that involved in the second offense is good when issued as drawer had sufficient funds in or credit with the drawing bank when issued. Under the first offense, the 90-day presentment period is not expressly provided, while such period is an express element of the second offense. The 90-day period is not among these elements. Section 2 of BP22 is clear that a dishonored check presented within the 90-day period creates a prima facie presumption of knowledge of insufficiency of funds, which is an essential element of the offense. Since knowledge involves a state of mind difficult to establish, the statute itself creates a prima facie presumption of the existence of this element from the fact of drawing, issuing, or making a check, the payment of which was subsequently refused or for insufficiency of funds. The term prima facie evidence denotes evidence which, if unexplained or uncontradicted, is sufficient to sustain the prosecution, it supports or to establish the facts or to counterbalance the presumption of innocence to warrant a conviction.